Strap in, folks. Today we're witnessing not one, but two sovereign citizen train wrecks in court. And from the very start, it's a cringe-fest masterclass. First up, Mr. A, if that's even his real name, storms in armed with a barrage of pseudo-legal gibberish. He proudly declares himself a living man, drops terms like sui juris, and refers to himself as a bibbed David of truth. Sounds deep. It's not. He's convinced these buzzwords are legal nukes, but they barely qualify as party poppers. What we're really seeing is someone using empty theatrics to avoid basic accountability. It's all noise, no weight, and you can tell the judge spotted the BS from a mile away.
We pronouncing that wrong. It is a fairly recent warrant. I would be comfortable addressing that on the record.
Yep, Mr. Hazeltine, are you able to turn on your microphone?
Can you hear me now?
Yes, sir. Okay, it looks like you missed your hearing on July 16th, just a few days ago.
I am, without recourse, sui juris, in propria persona, the living man, and not representing the incorporated Ty Warren Hazeltine entity. I am the affiant of the affidavit of truth filed in this case, April 26th, appearing specially and not generally under threat, duress, and coercion to correct the mistaken identity misnomer of the defendant, and notice this court to dismiss this case sui sponte for failure of joinder, failure to serve the complaint, failure to state a claim upon which relief can be granted, and lack of jurisdiction. Has someone entered a plea on behalf of the defendant?
All right, I'm not going to be able to address this case unless I have assurances that the defendant, Ty Hazeltine, is the person here, and I'm hearing a lot of nonsense that doesn't address directly, that rather obfuscates the clarity on who you are. If you're not Ty Hazeltine, then you're a spectator, and you're welcome to stay. If you are Ty Hazeltine, I'll address your warrant, but I will address no other issues in this hearing because this hearing is limited to quashing warrants and setting court dates. So are you Ty Hazeltine?
Does the caption of this case not say Ty Warren Hazeltine in all capital letters?
Your Honor, I can speak with Mr. Hazeltine in a breakout room if you prefer, or...
Well, he's not represented by counsel and hasn't been throughout this case.
He's refused counsel.
Yeah. If you're Ty Hazeltine, just tell me that. If you're not, then I'm going to let you spectate for the rest of the court calendar until we're done.
I am the affiant of the affidavit of truth, and if you look at the affidavit, it will clarify who it is that I am. There are two.
All right, I've muted your microphone. It appears to me that you don't claim to be Ty Hazeltine, so I'm going to strike Ty Hazeltine's hearing, and the matter will be, the warrant will be left outstanding. And Heidi, no one is eligible to appear on Zoom in this case. They have to apply in person for a warrant quash. All right, and sir, you're free to remain and watch the rest of the calendar. We're going to go on to...
The judge, armed with logic and an iron will, tries to steer the hearing back to reality, but our sovereign citizen friend isn't ready to leave his fantasy world. He refuses to identify himself as Ty Hazeltine, instead hiding behind a wall of legal-sounding nonsense. The court only needs something simple. Are you the defendant or just spectating? But with sovereign citizens, even basic questions spiral into philosophical rabbit holes. The judge remains calm but firm, ultimately letting the warrant stand. It's a slow-motion car crash of self-sabotage, and all this guy had to do was say his name. Instead, he chose nonsense over freedom, and paid the price.
Mr. Mathis, are you available?
Yep.
Good morning.
Grand Rising.
You are Anthony Winston Mathis?
No, I'm Anthony Mathis, the living man, here in special appearance for Anthony Winston Mathis, also acting in my proper capacity of the trustee of...
Mr. Mathis, today's the date and time for your informal hearing. The citation before the court, Mr. Mathis, indicates that on May the 24th of this year, at approximately 9 p.m., you are operating a 2024 Ford Edge, black in color, on 11 Mile Road, Air near Washington, in the city of Royal Oak. And at that place and time, you committed the civil infraction of impeding traffic. Impeding traffic, sir, is considered a lesser included offense within nearly any moving violation. And Officer Moran indicates in his detailed note that your vehicle was on East 11 Mile Road at Washington and disobeyed the traffic signal. The officer had a green arrow and therefore driver had a red light. Mr. Mathis, you have 3 options, and 3 options only, sir, in the protection of your own rights. You may, sir, admit responsibility in this manner. The court will attach the scheduled fine and that will close the case. Or, Mr. Mathis, you may admit responsibility with an explanation that you believe mitigates these circumstances, or you have every right to deny responsibility, and the court will swear the parties and will take testimony. What would you like the court to do for you today?
Well, I have a few questions, if you don't mind.
The court does mind. You need to make a plea. I am required by law.
No, I don't plead to anybody. I only plead to the Most High. Who are you?
I am Magistrate William Urick, P43273. I am a sworn judicial officer of this district. We are here for your informal hearing that you requested. This court is required by law, procedure, and court rule to take a plea. The motorist requesting this informal hearing, that being you, must make such a plea. You may admit responsibility in this matter.
I don't plead to anybody but God.
You may admit with an explanation, or you may deny responsibility, and the court will swear the parties and will take proofs. What would you have the court do for you today?
I don't plead to anybody.
Very well. Officer Moran and Mr. Mathis, please raise.
It could have been so simple. All he had to do was admit he missed court, say his name, and he'd be out with a new date. No drama. Instead, he took a nosedive straight into Nonsenseville. The judge even lays it out plain as day. This entire mess could have been over in seconds. But no, our guy sticks to his script of confusion and walks out with the warrant still hanging over him. And just when you think we've hit peak delusion, the next act rolls in, arguing traffic laws with cosmic logic and make-believe trustees. You honestly couldn't write this stuff, but somehow they do.
The testimony you shall give before this court shall be the truth, so help you God.
I do.
Thank you very much. Please proceed.
Magistrate, on May 24, 2024, at approximately 9 p.m., I, Officer Moran, was in the area of East 11 Mile in Washington when I observed 2024 Ford Edge, black in color, with Michigan plate Edward John Lincoln 6501. I was at the light at East 11 in Washington when I had the green arrow to turn. That vehicle then proceeded through the light. As I looked up at the traffic light, that light was red for that driver.
Very well. And with respect to your selection of citation, you elected to simply issue a ticket for impeding traffic. Is that correct?
I did, Magistrate, at that
And that's
time.
based on your discretion, your training, and your experience.
It is.
Thank you. You obviously have the right to rebuttal if you choose to use it, Officer Moran. Mr. Mathis, it is now your turn. What would you like the court to know, sir?
So, I have a question. Are you a judge?
Mr. Mathis, the court has already indicated it is a sworn judicial officer. It is exercising its jurisdiction lawfully over you. So, questioning the court's authority.
You don't have any jurisdiction over me. I would argue you don't have any jurisdiction. Okay.
Mr. Mathis, the officer has already testified as to the facts of the case. It is now your turn to testify. You can tell the court anything you wish the court to know, focusing solely on the events of the date in question. What would you like to tell the court?
The plaintiff is the city of Royal Oak. Please bring the city of Royal Oak. Where's the city of Royal Oak?
The officer is representing the city of Royal Oak, sir.
Where's the city of Royal Oak?
Are you asking where it is geographically, or are you asking where it is in
Right
terms
now.
of who's present on behalf?
Say hello to Anthony Matthews, or as he insists, the special appearance agent for his legal fiction self. Yes, it's as confusing as it sounds. When asked to confirm his name, he launches into a sovereign monologue that would make Shakespeare dizzy. The judge offers him the standard plea options, but Anthony goes full divine. I only plead to the Most High. And no, he's not referring to any earthly court. he means God himself. It's a courtroom, not a confessional. But sovereign citizens love to blur legal nonsense with spiritual grandstanding. And while the judge remains composed, you can see the patience slowly evaporating.
Doesn't understand your question. Are you asking where it is on a map or where is the officer?
No, I know exactly where it is,
Okay.
the geographic location, but where are they right now?
The officer is representing the City of Royal Oak as a sworn and certified Michigan peace officer. So, what else would you like to tell the court, Mr. Mathis? And please, again, the court suggests that you focus on the events of the date in question.
Okay, well, could you please bring forth the injured party? Was anybody injured?
This is not a tort case, Mr. Mathis. It is a case written
Well,
under the vehicle code
as
of
I
the
was
City of
traveling,
Royal Oak as it is adopted.
as I was traveling, the officer turned on the lights. No one was injured. So please bring forth the injured party. Based on the Constitution, the Sixth Amendment right, I have a right to face my accuser. If the plaintiff cannot come to court, then this shall be dismissed. That's failure.
Mr. Mathis, is there anything else you wish the court to know?
Please bring forth the injured party. If you can't bring forth the injured party, then this needs to be dismissed now.
Mr. Mathis, is there anything else you wish the court to know?
You guys can't bring anyone forward as far as the injured party. No one was injured. You guys.
Mr. Mathis, I will ask you one more time. The officer is representing the City of Royal Oak. This is not a case alleging physical harm or breach of contract.
Why are you trying to charge me?
This is a civil case
Why are you
under
trying
the
to
Motor
charge
Vehicle
me?
Code as it was decriminalized in 1979. This is a civil matter. The burden of proof is a preponderance of the evidence. The officer has testified as to what he observed, and it is now your turn to testify as to what occurred. There is no requirement under the rules of procedure, civil, in this operation as of today, that requires a quote-unquote injured party to be present. The officer has stated very clearly and fairly and plainly what he observed that day. So as to your testimony related to the date in question, is there anything else you would like the court?
With the defendant's identity still unresolved, testimony begins. The officer lays out the red light violation plainly, an open and shut case. But our self-styled sovereign citizen has other plans. Instead of answering, he launches into the usual theatrics. No jurisdiction, no consent, the whole recycled script. It's courtroom cosplay at this point. The judge reminds him this is a real proceeding, not a viral TikTok debate, but delusion is a tough armor. This isn't justice denied. It's justice dodged, loudly, and without results.
Thank you so much. Mr. Mathis, the burden of proof in a civil case is a mere preponderance of the evidence. The officer, a duly sworn and certified Michigan peace officer representing the City of Royal Oak, which is one of two cities upon which this court has jurisdiction, has put his testimony forward. There is nothing in the record that has rebutted any of it. Therefore, the court is finding you responsible for the citation as it was written. The fine for that, sir, is $175. That is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into the 44th District Court. Please don't interrupt the court, sir. You may walk a cash check or charge into the 44th District Court at 400 East 11 Mile Road, Monday through Friday, between 8:30 and 4:30. That's due within 7 days, Mr. Mathis. If you take exception to the court's ruling, you may post a bond in the amount of $175 within 7 days, and the matter will be placed upon the formal hearing docket of the Chief Judge of the District, and at that time, the City of Royal Oak would be represented by a city prosecutor. So either a bond or a fine of $175 payable within 7 days. That completes your hearing. Thank you.
We've officially hit peak sovereign citizen theater. He demands, "Where's the injured party?" as though he's discovered some hidden constitutional trapdoor. Then, mangling the Sixth Amendment, he insists the entire city appear in court to face him. Yes, a municipal entity, in person. The judge, remarkably composed, reminds him once again, this is a civil infraction, no one was harmed, there's no victim to march into the courtroom. But logic doesn't get a passport in sovereign land. These folks run on Google law and YouTube doctrine. not reality.